Attorney Cayosa and Justice Gutierrez. Please remain standing for the centennial prayer for the courts, the national anthem, and the Supreme Court hymn.
Almighty God, we stand in your holy presence as our supreme judge. We humbly beseech you to bless and inspire us so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, and fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen.
Bayang magiliw, pero sa silanganan, alam ng puso, sa titik mo'y buhay. Lupang hinirang, buyan ka ng magiting, sa manlulubi, di ka pasisingil. Sa dagat at bundok, sa simoy at sa langit ng baka, may nilang ang tula at awit sa paglayang nilaman. Ang kisap ng watawat mo'y tagumpay na nagtitigil. Ang bituin at araw niya kailan pa pa'y magdidilim. Lupa ng araw ng waraming pagsinta, ay langit sa piling mo. Aming ligaya dapat may mawapit at mamatay ng dahil sa'yo. Guardians of our rights, enrolled in majesty and light, uphold the fundamental law. From this writ, all their judgments flow. With conscience free their views to air, they vow and this to all declare. Rich or poor, friend or foe alike, God's scales are upon us strike. Justice and equity for all, love, truth, and fairness reign their horn. Stands the fourth of our sword, forever supreme court. Nation stands on history, their vision leaves a legacy. For their honor, their faith, their gaze, all nation their hope of praise. Justice and equity for all, truth and fairness reign their horn. Stands the fourth of our sword, forever supreme court. Nation stands on history, their vision leaves a legacy. For their honor, their faith, their gaze, all nation their hope of praise. For their honor, their faith, their gaze, all nation
The public interview of applicants for the position to be vacated by Justice Jose Mendoza of the Supreme Court is now open. Attorney Anama, please introduce to the council the names of the candidates.
Yes, Your Honors. Your Honors, the candidates to be interviewed this morning are, we have Court of Appeals Associate Justice Samuel H. Gerlan, Sandigan Bayan Associate Justice Alexander G. Desmundo, and Deputy Ombudsman for Luzon, OMB Gerard A. Mosquera. May I request Sandigan Bayan Associate Justice Desmundo and Deputy Ombudsman for Luzon, Mosquera, to stay in the holding room while the interview of Court of Appeals Associate Justice Gerlan is being conducted. Thank you very much, Your Honors. May I now request Justice Gerlan to occupy the hot seat?
Good morning, Justice.
Justice Gerlan, Your Honors.
That is really a hot seat. Are you now ready for interview?
Yes, Your Honor.
Okay. Please stand. Take your oath before the three of us. Do you swear to tell the truth, the whole truth, and nothing but the truth in this public interview?
I do, Your Honor.
Please take your seat. So good morning, Justice. May I now request Attorney Cayosa to start the public interview.
Good morning, Your Honor.
Thank you, Madam Chair. Good morning, Justice Garland.
Good morning, Your Honor.
Recently, we opened 2 vacancies in the Supreme Court. One on March 3, Vice Justice Reyes, and on April 5, Justice Mendoza. May we know why you opted to apply only for one of the 2 vacancies?
Well, I was recommended by my fraternity brothers in the International Order of Julyl, and when the Judicial and Bar Council asked me if, I'm in the Secretariat, if they asked me if I accept the recommendation, and I readily agreed because I believe that I have the qualifications to go up to the Supreme Court. I have been in the judiciary for 24 long years. I started as a municipal trial court judge in La Union for 8 years. Then I was promoted as a regional trial court judge, first in San Fernando, La Union, then transferred to Quezon City. I stayed in the regional trial court also for 8 years. Then got promoted in the Court of Appeals and in 2009. And I'm in the Court of Appeals also for 8 years. And for that long period of time that I've been in the judiciary, I only have one administrative case filed against me. That was when I was the regional trial court judge in Quezon City. And that case was even dismissed by the Supreme Court by way of a minute resolution. So I believe, Your Honor, that I am now ready to be in the Supreme Court.
I'm just curious why, if you were not nominated, then you would not have applied, knowing that you already have the qualifications.
No, I also intended to apply, Your Honor. It just so happened that somebody nominated me or recommended me. But it was also my intention to apply, Your Honor.
Now, you submitted to us your personal data sheet. The personal data sheet that the JBC requires is under oath, and therefore it should be a complete accurate and updated source of information. May I just know why you left the blank, the agency or office by which your wife is connected? It states here that she is a businesswoman.
Yes, Your Honor.
What business is she into?
My wife is a dentist, but she is not practicing her profession anymore. And so she is an entrepreneur. She is a franchisee of 7-Eleven, Your Honor. So that's why I put in as a businesswoman. Your Honor.
Although you state it was blank, no, for the NA for the agency office. And just so that the public may know, the reason why we require this information is so that in the future it will be referenced for any potential conflict of interest.
Okay.
Your children are both students still? May we know what school?
My eldest, Your Honor, is upcoming third year in San Beda College of Law. He graduated in LaSalle. My second son, I only have two children, Your Honor. My second son just graduated AB Philosophy in LaSalle also, and he will be entering the College of Law in San Beda too, Your Honor, where I graduated.
In the professional experience portion of the PDS, you left blank the items on supervisor. May we know who were you directly under as executive director of the Philippine Association of Securities Brokers and Dealers?
The Philippine Association of Securities Brokers and Dealers at that time, Your Honor, composed of the Manila Stock Exchange and the Makati Stock Exchange. So it is an association of stockbrokers. So I am under the supervision of the board of governors, composed of the president of the Makati Stock Exchange and the Manila Stock Exchange, the representative of the public investors. Your Honor.
How about as a legal counsel of Belson Group of Companies?
Well, my client was the late Eduardo Lim, Senior, Your Honor, a stockbroker, and who owns also other investment corporations, Your Honor.
And with respect to De Luna and Garland Law Office?
De Luna, Your Honor, Ambrosio De Luna, who is now a judge in Palawan, was my classmate in the College of Law. So we form a law office, Your Honor.
And finally, under the Public Attorney's Office at the DOJ?
I have a short stint with the Public Attorney's Office, Your Honor. I was assigned in Quezon City for just more than a year, Your Honor. And my immediate supervisor then was the late Attorney Parker.
You say for just a year. It states here that you were employed with the Public Attorney's Office from April 2, 1990 to June 30, 1993. Is that accurate?
Yes, Your Honor. Yes, Your Honor. I think 1991 to 1993, Your Honor. Before I was appointed as municipal trial court judge of Bangar, La Union, Your Honor.
Thank you, Justice. Now, I have here the judicial data and statistics of your monthly disposal. You have a total of 878 cases decided by resolution and 660 decided by decision. And your average monthly disposal is 14.63. Now, other applicants also, we have their statistical data, but some rank higher. Would you tell us how you decide which cases to work on first?
Well, Your Honor, under our IRCA, we have what we call as the priorities in deciding cases, okay, submitted for decision, Your Honors. And first, my criteria is to first in, first out. But I have to see also if a certain case, like in a criminal case, Your Honor, it involves a detention prisoner, then I have to prioritize, although they are not submitted ahead of some other cases. Like in civil cases, Your Honor, if I have issued a temporary restraining order or a writ, or there is or I issued a execution pending appeal, then I have to prioritize also, Your Honor, and also cases involving AMLAC or writ of amparo or writ of habeas data, whichever. I have to prioritize them, Your Honor. But most of the time, I follow the first in, first out policy, Your Honor.
Thank you, Justice. What would you consider as the most controversial case that you have handled as a Court of Appeals justice?
Well, honestly, Your Honor, I cannot remember. I haven't have any very controversial cases, Your Honor. I have concurred with my colleagues in the division, like just recently, the acquittal of Janet Lim Napoles, Your Honor. I was not the ponente, but I concurred, Your Honor. After going over the records, in fact, it took me several weeks before I give my affirmance to the ponente, Your Honor.
If not controversial, then the most memorable, perhaps, decision that you have rendered. Could you tell us?
Well, whenever I decide a decision, Your Honor, I don't concede. I don't concede. I consider all my cases as co-equal, something like that, Your Honor. So I cannot recall of anything that is so memorable on my part, Your Honor.
My time is almost up, but I just wanted to know, what do you think you would contribute, over and above all the, or compared to other aspirants for this position, that you feel would be a contribution that you could make to the court should you be nominated and appointed?
I don't claim, Your Honor, that I am more intelligently superior than the other applicants. In fact, I consider myself, like when I was a student, just an ordinary student, Your Honor. But when I passed the bar, I excelled. Your Honor, I was the one who, in our class, I was the one who first appointed to the judiciary, and at the same time, I was the one who was appointed first in the Court of Appeals. I am thinking of some of ideas on how to disabuse the mind of the public about their bad perception about the judiciary, Your Honor, most especially in the issuance of TROs and the flip-flopping, Your Honor, in the Supreme Court. Well, when it comes to, with regard to the issuance of TROs, Your Honor, like in the public perception, the bad perception of the public is that TROs are for sale. So perhaps we have to revisit the rules on the issuance of TROs. In my experience, Your Honor, I think in my stint, in my 8 years in the Court of Appeals, I can remember only of 2 instances where I issued a temporary restraining order. Most of the time, I ask the parties to comment and not issuing a TRO immediately. Once they submitted their comment, then I prioritize, Your Honor, in deciding the case, so that at least the litigants either will not think that I issued the TRO because of some considerations. And with regard also to flip-flopping, Your Honor, I think that, well, I read of a certain statement, I think from the esteemed magistrate, Mr. Justice Vicente Mendoza, that in the United States, motion for reconsiderations are not allowed. I'm not sure about that, Your Honor, but maybe we can look into that so that the public will not think that the Supreme Court is not sure of its decisions.
That was my last question. I wish you luck, Justice.
Thank you.
Thank you. Thank you, Madam Chair. I have no
Thank you
further
so much,
questions.
Attorney Cayosa. May we request now Judge Ilaw to continue.
Aras, thank you, Madam Chair. Yeah, good morning, Justice Garland.
Good morning, sir.
How are you today?
I'm good, sir.
So, did you initially plan to become a lawyer?
At first, Your Honor, it was my dream to become a doctor because I grew up in the province. I have seen in my neighborhood who cannot have an access to a clinic, Your Honor, or because I live in a far-flung municipality, Your Honor. And so it was my dream then, when I was still young, to become a doctor.
Doctor of what? Why did you take zoology as your prelo?
Well,
Doctor of what?
Doctor of Medicine, Your Honor. Doctor of Medicine.
So, why did you take zoology as prelo?
Well, that was the only. That was the first. That was the first course that came into my mind, Your Honor. So I took up BS Zoology. But during my student days in the Far Eastern University, I got involved in student activism. I also joined politics. In 1975, I was elected as a Kabataan Barangay chairman. We were the first elected then, Your Honor. And also I was also elected as Barangay Kagawad. So my interest shifted to law, Your Honor. So that's the reason why I shifted my interest to law. And besides, out of practicality and reality, Your Honor, my parents cannot afford me to pursue medicine.
How come the last seminar you attended was in 2013? Don't you agree that justices must always take the lead in updating themselves of recent legal development?
Yes, Your Honor. I apologize for not putting all the other seminars or symposiums that I have attended, Your Honor.
But you are being required to.
Yes, Your Honor. That's why, with apology, Your Honor, and I will try to correct what I left in the PDS, Your Honor.
All right, you have been with the judiciary for 24 years. This is a long time. What changes have you effected in those 24 years that make you worthy of a seat in the highest court?
Well, it might not be a changes, Your Honor, but I have maintained my my integrity, my independence, Your Honor, in the performance of my duties as a judge. I have been working diligently, especially when I was in the trial court. I conduct my hearings early in the morning, Your Honor. I go to my work and conduct hearings well prepared. So that I cannot say, Your Honor, that I have made some innovations at the time, but I have at least observed what is due to me as a judge or a magistrate.
According to your personal data sheet, your son Shalom is a student, but is also an executive assistant 6 at the Court of Appeals. How does he manage his time between school and full-time work?
Your Honor, my son is in the College of Law right now, and he goes to San Beda only, which is near the office, Your Honor, and his class starts at 5:30, so he has all the time to work in the office, Your Honor.
Don't you wish to hire a full-time employee that is 100% devoted to her task at the Court of Appeals?
Well, I can do that, Your Honor. In fact, I think it would be best for me to hire a law graduate, for that matter, so that at least he can also assist me in drafting even resolutions. But as an executive assistant, Your Honor, I also need somebody who will help me in the management of my office.
Alright, when asked by Attorney Cayosa regarding the more or less controversial case, you mentioned about the case of Janet Napoles, and you belong to the division in the Court of Appeals which acquitted Janet Napoles of the crime of serious illegal
detention, Your Honor.
What is your personal assessment of the case?
Well, first, Your Honor, the ponente was Mr. Justice Norban de Pizarro, and the other member is Mr. Justice Joseph Lopez.
What can you say about comments that such acquittal was politically motivated?
I don't think so, Your Honor. What I observed, in fact, is that there was, it's only my personal opinion, Your Honor. I think, Your Honor, it appears to me that, in fact, there was even pressure exerted, public pressure exerted before the regional trial court when when it found guilty again Janet Lim Napoles, Your Honor. But upon review, it appears to me, Your Honor, in my honest evaluation and opinion, it appears to me that no serious illegal detention was committed because the complainant, Mr. Louis, is free to go out, to contact his relatives outside while he was in Bahay, San Jose. That place, Your Honor, is a religious, spiritual retreat house. And I also consider the testimonies of even a priest, Your Honor, saying that he did not observe any actuations of Mr. Louis that will tend to show that his liberty was deprived by the accused. There was also a statement made, and it's on the record, Your Honor, that Mr. Louis was communicating with his family, and he never mentioned that his liberty was or security was deprived, Your Honor. And there were also instances that together with some companions, he went out from the Bahay San Jose to have dinner, and that was made in 2 occasions, Your Honor. And at the same time, when the NBI tried to rescue him, as they claim, Mr. Louis even uttered some words that some statements that in Tagalog na, "Ate, bakit hindi ako kinidnap? Walang ginawang masama sa akin si Jojo," referring to another accused, Your Honor, the brother of Miss Janet Lim Napoles. So those instances and facts made me to conclude that and made me to agree to the decision of the ponente, Your Honor.
What is your response to comments that her acquittal in this case would also result in her acquittal in the pork barrel case?
I don't think so, Your Honor, because that is another, it's a different case, Your Honor, pending before the Sandigan Bayan. In fact, right now, what I read from the news, even her request that she be transferred to the custody of the National Bureau of Investigation was denied by the Sandigan Bayan, Your Honor. So that I think it is, the Sandigan Bayan, Your Honor, will decide the plunder case based on their appreciation of the evidences that will be presented before them.
All right, there is a Twitter question observation that rating Court of Appeals very, very poor. What are your thoughts on the purported alleged corruption in the Court of Appeals? Because there was such occasion that even the Integrated Bar of the Philippines in Cebu City proposed to dissolve Court of Appeals, or rather, justices be returned to Manila.
Well, in my honest opinion, Your Honor, I don't believe that the Court of Appeals as an institution is tainted with graft and corruption, Your Honor. Well, it's just a bad public impression, Your Honor. That's the reason why earlier I discussed about some innovations, especially the issuance of temporary restraining order. Well, it is being published in the news, Your Honor, and it's being, I think, the public perception is particularly addressed, to the issuance by the Court of Appeals of TROs. Especially like the TROs are for sale, like what happened to the case of then Vice President Binay. In fact, the 3 justices who issued the TRO were even accused of being bribed, Your Honor, and I don't think so, Your Honor. I know and I can vouch for the justices who issued such a TRO, Your Honor.
And what are your personal undertakings to combat corruption, or the very least the semblance thereof?
Well, Of course, Your Honor, as a magistrate, I have to maintain my judicial independence, my integrity, Your Honor. I can socialize, but my socialization is limited to being, of course, I am also a member of society, and but it does not necessarily mean, Your Honor, that I can be influenced by my social groups or my friends. I have so many organizations, Your Honor. I am a frat man, and in fact, I'm also a member of the Couples for Christ, a Freemason. I joined also their activities, Your Honor, but I see to it that I will never be influenced by them.
All right, my last question. So discuss your platform for the judiciary. Of course, this must include novel reforms that you must be chosen for the vacancy.
If ever given the chance, Your Honor, first by this good counsel in giving me the opportunity to be nominated to the President and eventually be appointed by the President, Your Honor, I will be staying in the Supreme Court for at least 11 years, Your Honor. So I believe, Your Honor, that with that long period of time, I can be of help in dispensing true justice to our fellow men.
All right, thank you very much, and thank you for your time, and good luck to your journey.
Thank you, Your Honor.
Thank you so much, Judge Julyl. You see, Justice, one of the rules of the JBC requires that the candidates, in determining the candidate's qualifications, his or her mastery of laws, rules, and jurisprudence must also be tested by the council.
Yes, Your
And I
Honor.
think that's my part. So right now, Justice, the Supreme Court in Bank is deliberating on the petition filed by 333 lawyers et al., questioning the constitutionality of the declaration of martial law by President Duterte. And most of them have submitted their own opinions. Now, if you are one of them, how will you decide the case?
Well, it's an academic discussion, Your Honor.
Yes, of course.
Because it's still sub judice. I think.
But we can discuss it
Yes,
right
yes, Your
now.
Honor. Yes, Your Honor. They are mandated by the Constitution to decide it until, I think, until tomorrow, Your Honor. So, in my honest opinion, Your Honor, if I am the one who will decide the case, I believe, Your Honor, that there is a sufficiency of the factual basis in the declaration of martial law.
What do you mean by factual basis? In other words, are there grounds
Yes,
for
there was
the President to declare martial law? What are the grounds?
rebellion or invasion when public safety requires it, Your Honor. And I believe there is a rebellion, Your Honor, because as observed by Mr. Justice Mar del Castillo, the Maute group raised
Don't
a...
quote him
Okay.
as you are the ponente, as what you have observed personally.
Okay. Well, as I have observed and read from the news, Your Honor, there was really a rebellion going on, perpetrated by the Maute group.
Can you define rebellion under the revised penal code? What is rebellion?
Well, rebellion, Your Honor, is committed when a group of persons raising up arms against the government and taking away allegiance from the government
For the purpose of
establishing removing allegiance from
the
yes,
territory of the Republic of the
territory of the
Philippines
Republic.
or a part thereof,
yes, Your Honor.
and what?
And establishing a government of their own. And in the case of the ongoing rebellion,
Depriving the executive and
to exercise
legislature
the sovereignty
to
of
perform their powers,
powers
of function.
over the said.
So these requisites of rebellion are present.
I believe so, Your Honor.
Invasion also. Okay, can you, as the ponente, order the two houses to convene and declare at this point of time that there is a factual basis for the issuance or for the declaration of martial law?
Well, the provisions of
The
the
Constitution is provision on that score is mandatory. Both houses should have convened,
jointly.
but they did not.
Yes, Your Honor.
What will be your decision on this point?
Well, I will be guided by the ponencia of Mr. Justice Abad in the case of Fortune versus GMA, Your Honor. Although the court they decided that it's already moot and academic because
Because GMA lifted.
GMA lifted.
But in this case,
yes, Your Honor. But
the martial law is ongoing.
yes, Your Honor. But there was a statement made by the court that it's not the joint convening of the Congress is not only limited to revoke or to extend the declaration of martial law, but also to affirm the declaration of martial law. So I believe, Your Honor, that Congress must have also to
It should
convene.
convene.
Yes, Your Honor, I believe
Okay,
so.
let us see what the decision of the Supreme Court will be. Justice, what do you mean by a constitutional court?
A constitutional court, well, I think those courts created by the Constitution, Your Honor.
Constitutional court is a court which only determines and decides
Constitutional
issues.
decisions.
Do you think and believe that there should be a constitutional court in our country?
I believe so, Your Honor. So that that's also one of my I think if ever given a chance, I think the Supreme Court powers
What will be
will
your
be limited
basic
only in resolving constitutional issues, Your Honor.
There should be a constitutional court in this country because our Supreme Court is overworked. It's loaded with so many kinds of cases.
Yes, Your Honor. Yes, Your
So
Honor.
there should be a constitutional court, a court which will only resolve and determine constitutional issues being raised there. So it requires a constitutional amendment.
Amendments, yeah.
Okay.
I agree
How
to
about
that.
federalism?
Well, federalism, I don't have so much idea about federalism, Your Honor. But
in your mind,
in my mind,
what is federalism?
Federalism, Your Honor, is giving autonomy to a certain region wherein they can exercise
Meaning, basically, it is to decentralize
yes, Your Honor, power
powers
in
of the
one
government,
yes,
to
the central.
separate the powers of the national government from the local governments.
Yes, Your
Do
Honor.
you think this will be a wise move if the Constitution will be a change from unitary to federalism?
Well, I think so, Your Honor.
Why?
In that way, that will also address the clamor of our Muslim brothers in the south, in Mindanao.
You're only referring to Mindanao.
Well,
How about
not-
Luzon, Visayas?
Even in the other parts of the country, Your Honor, so that at least the concentration of power is not only confined to Imperial Manila, as what.
So how will what do you think? How will this federalism work each province will be independent from each other. Each province will have its own government, its own judiciary, its own legislature, its own executive, its own police, its own civil service. How? Do you think we are ready for that?
That's another question, Your Honor, whether we're ready for that. I believe that at this time, we have to
Just
have
answer yes or no. Are we ready?
No, Your Honor.
The President might know your answer. Okay, you mentioned a while ago, in answer to the question of Attorney Cayosa, that among the many matters you will bring to the Supreme Court is this, the avoidance of flip-flopping decisions. Okay, remember, justice, you're only one. You will be 15 there. And even if that is your intention, it's easier said than done. You can do that only if you're alone. You can avoid flip-flopping, but since you will be 15, that is very, very difficult to do. Anyway, can you cite 5 decisions at least you consider flip-flopping rendered by the Supreme Court, especially written by Justice Brion?
The PAL case, Your Honor, involving the stewardess and the stewards. Okay. The PASAP,
Another 4 decisions, Justice.
the Dumagat case, Your Honor, involving the creation of a city out of Surigao.
This creation of a province.
Province, I stand corrected. And also the
Province of Dinagat Islands.
Islands,
Okay.
okay. And the other one is the case also of the creation of other
Cityhood.
cityhood, Your Honor.
Another one. Another 2.
Another 2. Well, cannot recall, Your Honor.
You can review jurisprudence.
Yes, I will do that, Your Honor.
Okay. Let's see. Let's go to the Constitution again. You are aware, of course, of the doctrine of search incident to arrests.
Yes.
Supposing Justice, a Filipino, Juan de la Cruz, is driving a vehicle, but along the way, the driver met an accident. He overran a pedestrian on the side of the street. Okay. So the police, because there was a crime being committed, arrested him. But when the driver was being arrested, the policeman saw a cell phone beside the driver. The question is, can the police seize the cell phone? Because there was no search warrant over the cell phone. But can he seize it? Because he saw the cell phone beside the driver.
Under existing jurisprudence, Your Honor, if my memory serves me right, in case of a search of a vehicle, the policeman can only search the or seize items.
We are talking here of arrest and the cell phone, whether the policeman could seize the cell phone.
Well,
There is an arrest. The policeman is arresting the driver.
he was arrested because of he committed a crime. But they cannot just seize anything which is not, by just having a cell phone on his side. I think they cannot
Can
just.
the policeman get the cell phone also?
They cannot, Your Honor.
You see, the policeman got the cell phone. And when he scrolled the cell phone, there were messages and information to the effect that this driver is involved in drug activity.
Well, it is different, Your Honor, if what was seen as a result of the lawful arrest, as an incident of the lawful arrest, are items which it is also illegal. Like when the
Is
policeman.
the cell phone illegal?
No, Your Honor. That's the reason why I said that they cannot just
But
confiscate.
I told you the cell phone contains information constituting a crime.
Well, in the first place, they don't have the right to confiscate the cell phone, Your Honor.
That is not a search incident to the arrest.
Yes, I believe so, Your Honor.
Well, we don't have, because we have now this modern technology, and there are no rules respecting to this laptop, cell phone, etc. So, in the U.S. Supreme Court, there has been a decision on this. And you are right, the policeman could not just seize the cell phone. There is a need for a search warrant. Can policemen who are equipped with search warrant enter the house and then just then and there confiscated and seized all the articles inside? Supposing the crime being charged is about drugs.
Well, under the plain view doctrine, Your Honor, as long as those items are used in the commission of a crime, when because of a valid search warrant, they see in plain view a kilo of shabu or other items, let's say a firearm, an unlicensed firearm, then they
Again,
have.
let's go to modern technology. Because of an electronic device, policemen use that electronic device so that, over the window of your house, the policeman could see plants suspected to be marijuana planted in your pots. Okay. Because of that, can the policeman or policemen just enter your house right then and there because according to them, the plants are marijuana?
Well, I don't think so. They still need to have they have to secure first a search warrant before they
Okay,
can.
they secured a search warrant. When they entered the house, they found truly you have marijuana plants inside your house. You were convicted, you're gone.
Well, in that case, as I have said, under the plain view doctrine, in as much as the policeman
There has been a decision by the Supreme Court. Mere suspicion, even if they secured search warrant, that is violation of the Constitution. That no
Against privacy.
person or people should not be searched in the absence of search warrant. I have yet so many questions, but then there is the warning, so good luck, Justice.
Thank you, Your Honor. Thank you very much. Sir.
Nominated.
Next candidate to be interviewed, Your Honors, is Sandigan Bayan Associate Justice Alexander G. Gasmundo. Justice Gasmundo, Your Honor.
So good morning.
Your Honors.
Justice. Okay, I think we should first administer your oath. Do you swear to tell the truth and nothing but the truth in this public?
I do, Your Honors. Thank you.
Now, Attorney Ayosa to start.
Thank you, Madam Justice. Good morning, Justice Esmundo.
Good morning, Your Honors.
Now, from your personal data sheet, you divulged that there were 2 cases filed against you.
Yes.
One was filed by certain. Here we go. Was sorry. Here, Maria Cecilia Hipolito.
Yes.
You were a co-accused, or at least a respondent still, no? With Jose M. Calao. Could you tell us something about this case?
Well, it's a case many years ago. It's a case of being at the wrong place at the wrong time. Because on a weekend, I think my nephew asked me if I can drive for him to pick up his daughter. So I obliged, and we went to the place in Nueva Ecija. And as soon as we get there, he left the car, went inside the house, and then brought his daughter out. And then a few days after, it turns out that the child was taken without the consent of the mother. So they filed a complaint, I think, with the prosecutor's office. So we appeared there, and after clearing out things, it's just a case of misunderstanding between these people.
Jose M. Calao is your nephew?
Yes,
And the mother of the girl that you fetched
yes,
was Maria Cecilia Hipolito.
yes, Your Honor.
What has happened to your nephew and to the girl since that
They
time?
never lived together, I think. They never lived together.
Were they married?
No.
And you had no inkling that, because I believe this happened when you were still with the Office of the Solicitor.
That's correct, Your Honor. Long time ago.
So you had no inkling that there was anything going on
No, I
between
did
them?
not know that there's such a thing.
You also divulged that you had a case filed by Crispin T. Reyes. There were several of you who were respondents in this case. Could you tell us something about this?
That was at the time when I was at the PCGG, Your Honors. There was this issue on the alleged refusal of the PCGG to recover the something like 13.2 billion US dollars purportedly deposited in the name of Irene Marcos, Araneta Marcos. And this Anti-Graft League of the Philippines, through Mr. Crispin Reyes, filed a case against us because he was telling that we are refusing to take effort to recover this amount. On the basis of that, he filed a complaint against all the members of the PCGG then for both administrative and criminal cases because we refused to pursue that recovery. It turns out later that per verification that account never existed. So there's no such Irene Araneta account. In fact, it was the subject of a Senate inquiry, that particular incident. So the cases against us were ultimately dismissed.
The records would show that as early as in 2009, you submitted an application for the position of Associate Justice of the Supreme Court.
Yes.
It has been 8 years since your last application. Could
That's
you-
correct, Your Honor.
And I believe you were even shortlisted.
Not, Your Honor.
Okay, well, anyway, may I just know why it took you 8 years to apply again for the Supreme Court?
Well, I did that pursue application thereafter because first, I enjoyed the work at the Sandigan Bayan. The responsibilities come with the position and the heavy workload, you know, at the time I did not have much time to focus on that matter of pursuing the application to the Supreme Court.
In your personal data sheet, you also divulged that you have, as of the time that you applied, no, or submitted the PDS, a caseload of 586 with a monthly average disposition of 2 cases per month. Is
Yes,
that
Your Honors.
accurate?
Yes.
Now, but notwithstanding the 2 cases monthly disposition, you have 100% disposition rate.
Correct, Your Honor.
So, has the number of cases that are assigned to you been increased? Because comparatively speaking, the case disposition of 2 would seem rather low.
That's correct, Your Honor. Because the situation in the Sandigan Bayan is that cases takes a while to be tried and to be submitted for decision, owing to the complexity, such as, for example, the number of cases filed against the number of accused. Invariably, when a case is filed in the Supreme Court against public officials, this will involve at least minimum of 2 cases, violation of a specific penal law, and then the corresponding violation of RA 1319. And these cases are tied together. So it may take some time before the case is actually submitted for decision.
So in connection with this, I would want to adopt this tweeted question, which was specifically addressed to you. And the question is, what is your guideline in the application of balancing tests in inordinate delay cases?
Well, jurisprudence, the most recent of which is the decision of the Supreme Court in the case of Remulla versus the governor Maliksi, where Justice Mendoza, the ponente, made a distinction between 2 sets of cases dismissed by the Supreme Court on the ground of inordinate delay. The balancing of interest test, to put it simply, is that if there is a delay, should it warrant the outright dismissal of the case? Under the concept of balancing of interest, you look at the reason for the delay in the conduct of the preliminary investigation. Because while it is true that an accused or respondent is entitled under the Constitution to the speedy disposition of cases, equally true is the right of the state to prosecute these people. So in terms of measuring whether to dismiss the case by reason of inordinate delay, several factors will have to be considered. Among them, who is primarily responsible for the delay? It is possible that the accused himself is responsible for delay because he does not timely file his pleadings. Sometimes he asks for motion for reconsideration. On the other hand, the delay also can be attributed to the prosecution because it takes them a while to conduct their preliminary investigation as well as what they call fact-finding investigations. So these 2 apparently and seeming conflict between the right of the accused and the right of the state to prosecute must be taken into account before we should allow the dismissal of an action based on an ordinary delay.
Sometimes there is also delay attributable to the judiciary itself.
That's correct, Your Honor. That we cannot deny.
Should you be nominated and appointed to the High Court, what would you recommend in order to address the question or the problems on delay of resolution of cases?
Well, Your Honor, I was tasked and part of the Supreme Court Committee, Special Committee on Speedy Disposition of Criminal Cases. And there we recommended a number of things to address the issue of delay. Delay would be caused by several factors. Typical cause of delay in court proceedings is when an information is filed in court. There is that propensity of accused to file a motion for determination of probable cause, which technically would require the court to resolve. Now, in that guidelines that we adopted and recommended and to be implemented starting September 1 of this year, we considered motion for the determination of probable cause as a prohibited pleading. So that that incident will have to be done and over with. No more motion for determination of probable cause, because the motion for determination of probable cause will minimally require, 30 days, because we will require the respondent to comment also. So, since the rule is very clear that when an information is filed in court already, 3 options are available to the judge. 1, if based on the records, he can outrightly dismiss the case, he ought to dismiss it. If he finds probable cause, he should issue a warrant within the 10-day period. And last, if there's a need for additional evidence from the prosecution, they should require the prosecution to present additional evidence. Now, if there is that motion for determination of probable cause, which should no longer be allowed because it is the duty of the court to issue the warrant of arrest within the day period, that at least will shorten 30 days delay. That's among others that we considered in the SPD disposition of criminal cases. Another thing that we should consider to avoid delays in the proceedings is that the judges must now be given a proactive role in the actual processing of a case before a court. Invariably, courts have been passive, and this I learned when I was part of the study group recently in the United States under the U.S. Department program on speedy trial. And there we learned in our interaction with judges that the active role of judge is important. He should control the calendar of the case, not the litigants. Flimsy excuses for continuance should never be allowed. In fact, one judge commented during the discussion that the only excuse that she will accept for continuance is when the lawyer is dead. Otherwise, they should allow all these dilatory maneuverings of counsel. I hope that we can adapt that to address the issue of speedy disposition of cases.
Thank you, Justice. Now, we elicited some comments as regards your work and your work ethic. And we noted here that while you live in Las Piñas, you are able to still come to work early. I'm just wondering, you live in Las Piñas, you work in Quezon City, and you still manage to teach in Makati. How do you manage that?
Well, basically, Your Honor, traveling for me is quite a task every day. But the advantage is that we have a driver. We are provided by the court. So I can sleep along the way. Because traffic in this country, or at the moment in the metropolitan Manila, is totally unpredictable. But I follow the law of physics. The short distance between 2 points is a straight line. Once I reach EDSA, then go all the way to Quezon City. As far as teaching, I have been away from school for quite a time. It was only this semester that I resumed teaching. And teaching up to about 8 o'clock in the evening should provide me some little comfort because ordinarily traffic is a little lighter except on rare occasions that as you leave the school area, traffic is heavier.
You state here that your wife is retired. Retired
Yes.
from what?
She retired from her employment with the California State Public Utilities Commission.
And I understand that throughout your career as a jurist, your family has been
In the United States.
Why have you decided to continue to live here, notwithstanding the fact that your family is abroad?
Well, as I would tell my children, life is never perfect. You have to give up something to gain something. But there are personal circumstances that forced me to come back to the Philippines.
And finally, how is your health?
Well, per latest medical clearance, the doctor said that I'm physically fit, clinically stable, although I am on maintenance medicine.
Yes, your records show that you underwent
Bypass surgery.
Yes, artery bypass graft surgery. And do you continue to have diabetes?
Yes, Your Honor, but I'm on insulin and other maintenance medication.
And was this also brought about by your smoking habit? Have you seen?
I would not deny that part of it is a smoking habit, Your Honors.
Do you continue to smoke?
Yes, I do, Your Honor.
And it also states here an occasional alcohol intake.
Sorry, Your Honor.
And due to occasional alcohol intake, would you care to comment?
Occasional alcohol intake. I do not drink very often, Your Honor. I drink only alcohol most of the time wine, on social occasions.
Okay. And my final question, what changes will you have to make in your life, both with respect to your body and perhaps your lifestyle, should you be nominated and appointed to the High Court?
Well, first things first, I'll try my best to quit smoking. And then go on diet and exercise.
With that, Justice, I wish you luck. Thank you.
Thank you very much, Your Honor.
Thank you, Madam Chair.
Thank you, Attorney Cayosa. May request now, Judge Julyl.
Thank you, Justice Gutierrez. Good morning, Justice Gesmundo.
Good morning, Your Honor.
Seems that Attorney Cayosa, personally you, is he a classmate of yours or a schoolmate? I schoolmate only.
We belong to the Ateneo Law School, Your Honor.
Okay. And according to her, according to your record, that you are physically fit, about mentally.
I suppose, yes, it's included
Sorry.
in the,
That's just a joke.
it's included in the, I think, in the evaluations.
Psychological evaluation.
I have not I have not heard of the results, Your Honor.
Okay. You initiated the development of electronic records in the Sandigan Bayan.
Well,
How
I was
do-
part of the MIS before, but when I assumed the 7th Division chairmanship, the division decided to conduct out-of-town hearings. Most recently is in Davao City. And in my experience, when we go out-of-town hearings, we normally physically bring the records of the case. So we would travel to Davao or Cebu with 3 luggages containing all the records of the cases. So when I assumed the chairmanship of the 7th Division, I thought of adopting a system where we can minimally bring records for out-of-town hearings. So I discussed it with my colleagues at the division, and we agreed that for practical reasons, we should have these records that are relevant for our out-of-town hearings be scanned and saved in a portable hard drive. And we brought along, each and every one of us, individual laptops. So we have minimized the taking of physical records in out-of-town hearings and simplify things by using the technology. So now we can access records at any given time while we are out of town hearings.
So what similar contributions do you intend to initiate and implement in the highest court if and when you're appointed as such?
Well, I will try to put additional inputs on addressing the issue of speedy disposition of cases. This has been the perennial problem that besieges our jurisdiction. I would recommend perhaps the revision of certain provisions of the rules of court, like for example, in civil actions. Because under existing provisions of the rules of court, the earliest time that the court can see the evidence is at pre-trial. And pre-trial takes a while from the inception of the case. So in my view, and I humbly submit that perhaps we should revise the provision on the rule on pleadings, which requires that for purposes of initiatory pleadings, the allegations must be limited to ultimate facts only. Evidentiary matters are not required. In my view, the earliest possible time that the court can have access to the evidence would expedite the proceedings, because when the case reaches the pre-trial, the court had already an idea of what are the causes of actions and the defenses and the evidence to prove this cause of action or cause of action and the defense raised by the defendant. I would also recommend that, again, for civil actions, we should make it mandatory that all modes of discovery must be strictly complied with. The case should not reach pre-trial until parties have exhausted the modes of discovery. I learned that during the trip in the United States, that the rule in civil cases and to a certain extent in criminal cases putting a case in the calendar for trial is the exception to the rule, because cases must be terminated at the pre-trial level. Because at that point in time, parties and court would have already evaluated the evidence to be presented by the parties. So that at that point in time, a proactive judge can tell the parties that based on what is before me, I can render summary judgment, or I can render judgment on the pleadings. This case need not go to trial. Or, if it should go to trial, the issues to be tried are already limited, thereby cutting off the duration of the trial. Those are the two basic things that I would strongly recommend that should be looked into, Your Honor.
All right, we take note of such laudable objectives. But yet, how come that your caseload in the Sandigan Bayan is 586, yet your average monthly disposition is 2? Don't you have any guidelines?
Well,
While we are in the, when I was then the RTC, we had a 90-day period within which to resolve to decide a case. How about the Sandigan Bayan?
the peculiarity of cases in the Sandigan Bayan is that cases invariably would have several accused. As I said earlier, one set of accused will be charged a number of criminal cases arising from the same transaction. Violation of the provision of the revised penal code or violation of Republic Act of 1319. Each of the accused invariably will be represented by a different lawyer with different legal strategies. So, along the way, these several lawyers would contribute to the delay. But addition to that is that sometimes the reality is that both the prosecution and the defense are unable to bring their witnesses to the Sandigan Bayan. Because we should note that the Sandigan Bayan's jurisdiction over practically all over the country where any public official is holding office. So experience showed that for accused or even prosecution witness who are residing in Mindanao, which will require financial and logistical support, this contributes to the delay also. And sometimes the complexity of the case also would cause the delay in the disposition of the case at the Sandigan Bayan. So those are the several factors that contributes the delay. That we do not deny, Your Honor.
All right, are the justices in the Sandigan Bayan not ready to counteract all factors that may contribute to the delay of the cases?
We are doing that, Your Honor. In fact, with the recent amendment of the Charter of Sandigan Bayan, allowing 2 justices to sit and receive evidence instead of the existing rule that requires 3 justices, that would expedite to a certain extent the disposition of cases. Another amendment that would expedite the proceedings under that amendment is that we will no longer have a situation where a case is to be decided by a special division of 5. Because under the amendatory law, the votes of 2 justices will be enough to render a judgment in a case. Because under existing procedures, if one dissent of the 3 justices, 2 new justices will have to be added to review the decision. So those instances, Your Honors, I think we can expedite.
All right, so you mentioned also about your proposal to get rid with this judicial determination of probable cause. Let's remember the corpus versus mogul principle doctrine.
That's correct, Your Honor.
But that has already been override by other cases, by Solar Entertainment, that the settled jurisprudence merely states that it is within the prosecution arm of the government belongs to determination of probable cause. unless there is a grave abuse of discretion. Am I correct to say this, Justice?
Yes, I agree with you. As we all know, the determination of probable cause would consist of two aspects. First is the determination of probable cause by the public prosecutor, whether to file an information or not. That is an executive function. The second is determination of probable cause by a judge for purposes of issuing a warrant of arrest. But the rule is that once an information is filed in court, as enunciated in Crespo Mogul, the control already is with the court, and any action that the prosecutor may make, such as filing a motion for reinvestigation, it is within the court, and the court is not bound by the recommendation of a public prosecutor. So if the court decides that there is no reason for investigation, then he should deny it. And no abuse of discretion can be attributed to him, because that is what the jurisprudence and the rule says. The court is already in control of the case once an information is filed in court, Your Honor.
Alright, as Sandigan Bayan Justice, what is your competitive edge over justices of the Court of Appeals?
Competitive edge, I suppose we are with the law requires the same qualifications for all justices of the collegiate court. The competitive edge of a Sandigan Bayan Justice over the Court of Appeals justices
Who are now applying as
for the same position, Your Honor, I think it would matter based on individual qualifications. Because the
for the
exposure...
fact that Sandigan Bayan has only limited jurisdiction as
That's correct,
compared
Your
to the
Honor.
Court of Appeals.
That's correct, Your Honor. But as I mentioned earlier, it will depend on the individual qualifications, because justices of the Court of Appeals and justices of the Sandigan Bayan would have different beginnings, in the sense that in terms of practice of law, they came either from private sector or they came from the judicial rank. But there are those justices also of the Sandigan Bayan who came from the office of the Solicitor General, where we had the opportunity to be exposed to all the kind of litigation. So in that sense, I would say that when we speak of differences or advantages or edges, it really boils down to the issue of the individual's experience and qualification, Your Honor.
Alright, my last question. You were recommended by the Ateneo Law Alumni Association
Yes, Your Honor.
and Justice Maria Teresa Dolores C. Gomez Estuesta,
Yes, Your Honor.
and you accepted such
Yes, Your Honor. I
recommendation?
signified on the last day of the application last day for filing an application, a covering letter accepting the nomination of the Ateneo Law School and Justice Estuesta.
So if you got the position because of their recommendations, how are you going to refuse favors from them in the future, should there be any? Are you not going to be beholden to them?
I don't think that the Ateneo Law Alumni Association recommended me with some interest in their mind. I think they were objective in giving that recommendation, as well as Justice Estuesta. At the end of the day, these recommendations are, to me, I can only say thank you to them. But when the task is to be done, I don't think it will matter at all.
Hopefully. All right, thank you.
Thank you,
Good
Your
luck
Honor.
also.
Thank you so much, Judge Ilaw. Good morning again, Justice.
Good morning, Your Honor.
Very good credentials. So, just few legal questions,
Yes, Your Honor.
especially the Constitution, I've been teaching legal subjects, etc., etc. Okay. Of course, you are aware about this incident involving the 6 provincial officials being detained by the committee of the
In the
lower
lower
house.
house. Yes, Your Honor.
And of course, you are also aware the 3 justices of the Court of Appeals issued a writ of habeas corpus.
Yes, Your Honor.
And he then, bailed out these 6 public officials. Okay, supposing you are now a justice of the Supreme Court, and this case reaches the Supreme Court, you are the ponente, and the petition has been filed by the 6 provincial officials claiming that their continuous detention by the lower house is unconstitutional. Okay, how will you resolve the following issues? Number 1, is the action of the 3 justices in issuing the writ of habeas corpus in accordance with the Constitution? That is the first issue.
Your Honor.
Please resolve.
Your Honors, the provisions of the Rules of Court, specifically Rule 102, habeas corpus, in Section 1 provides 2 instances where the remedy of habeas corpus may be availed of. The first instance is where a person is denied of liberty. He is in detention. When you speak of habeas corpus, there are 2 stages to be reckoned with. First, where a petition for habeas corpus is filed in court, the first step that the court should do is to issue as what we call preliminary citation. That is not the writ itself. A preliminary citation order by the court in habeas corpus proceeding simply requires first the respondent who is holding custody of the person subject of the petition must bring him physically to the court. Second, that preliminary citation should also require the respondent to make a return on the writ. Meaning, if you are a public officer who is detaining a person, in your return, you must specifically allege the reasons why you are detaining that person. And that return of the writ, as far as that first situation in habeas corpus petition is concerned, constitute a prima facie evidence to prove the reason for the detention.
Was that complied by the 3 justices of the Court of Appeals?
Honestly, Your Honor, because I did not see any account that there was an order of preliminary citation.
There was none.
I'm not sure, Your Honor.
There was none.
There is no...
The 3 justices merely issued the writ outright.
Because the third stage in habeas corpus proceeding is when the detainee is brought before the court together with the return. That is the time the court will hear the petition and find out
I'm telling Justice, there was none. So proceed with your resolution.
Okay. So, in that case, there were procedural lapses observed. And therefore, I would say that this is a defect that should be addressed to, and therefore, under that circumstance, under the parameter that there was no order coming from the court that a return be filed by respondent, that would be an error, and therefore it should be corrected.
So the reason why the 6 provincial officials will declared in contempt by the lower house is because they refused to answer the questions. Okay. Is the petition for a writ of habeas corpus the proper remedy that should have been resorted by these 6 officials?
Your Honors,
What should have been the remedy in your
in my view, under that situation, let me recall the ruling of the Supreme Court in Arnold versus Nazareno, where the Supreme Court upheld the right of the Senate to put into detention. In fact, Arnold was jailed in the National Penitentiary for his refusal to answer. And the Supreme Court said that it is the right and within the powers of the legislative body to cite in contempt persons appearing before it who refuse to give an answer.
Yeah, that's the leading case. So, what should have been the remedy of the provincial officials
I would have said
instead
that
of habeas corpus?
I would have resorted to certiorari.
Rule 65.
Yes, Your Honor. Under the expanded judicial power of review, under the Constitution, I would allege and prove that there was grave abuse of discretion in ordering the detention. It may not be as expedient as habeas corpus, But I think that is the proper remedy. The courts now, under the provision of the Constitution, is granted that the judicial power includes the power of the courts to determine whether or not there is grave abuse of discretion on the part of other government agencies or instrumentality.
That expanded jurisdiction was not provided for by our 1935 Constitution,
That's correct, Your
but
Honor.
only by the 1987 Constitution. Can you trace the history of that expanded jurisdiction?
Well, basically, let's start from the point of view of what is judicial power.
Where did this judicial power emanate?
Judicial power, according to the leading case of Madbury versus Madison, is that judicial power in the United States extends to all cases arising under the Constitution. The court should not be deprived of its authority or jurisdiction to review actions of other co-equal branches of government. The original concept of power of judicial review under the old Constitution, limiting the power of courts to review only executive and legislative acts. That is the ruling in, I think, in Angara versus Electoral Commission. Subsequently, because
No. Can you relate to us the facts concerning this Marbury versus Madison?
Marbury versus Madison, it's
And how the Chief Justice John Marshall arrived at that conclusion?
if my recollection of my political or constitutional class is correct,
Teaching that.
Madbury was appointed by President John Adams as a justice of the peace in the county of Washington, District Columbia, State of Columbia. Madison was the Secretary of the State at the time. Because Madbury wants to assume his office, to which he was appointed, he requested
Under our Constitution, that was a midnight appointment by President
Yes, because at
Adams.
that time there was transition. John Adams had finished his term. So he was requesting that he be given a copy of his commission. Because under the United States,
Commission or appointment.
there's 3 stages, as the case told us, that in the appointment of government officials in the United States, there should be first nomination, appointment, and commission. The commission completes the process because at that point in time, the appointment papers had been signed already by the President. And the responsibility of the Secretary of the State is to affix the Great Seal of the United States and record the appointment. In that case, Madison refused to release the appointment of Madbury. Madbury went to the Supreme Court of the United
Upon
States.
instruction of President Jefferson.
Correct, Your Honors. So he went to the United States Supreme Court on a petition for mandamus, if I recall it right. Mandamus to compel the Secretary of the State to release his commission because he cannot assume the office absent that piece of paper and its jury recording. So it was a case of first impression, I think, in the United States Supreme Court at the time. So there were several questions that the court asked itself. First, did he have a right to demand a copy of the commission? They said that if there is a right, there should be a remedy. There is an injury, there should be reparation. Next question they asked, is the remedy proper, mandamus, considering the provisions of the United States Constitution? There is no mention that the U.S. Federal Supreme Court would have original jurisdiction over mandamus petitions. Third, what is the judicial power that we can exercise? What is the nature of mandamus proceedings? So they made distinctions between what is discretionary function and ministerial function of the President. According to the jurisprudence, when there is the point in time that the President can decide what it should do or he should do or not do, that will be an exercise of discretion. We cannot compel him. But the
And
moment
there was a fear on the part of the Chief Justice Marshall that President Jefferson would not obey the mandamus order.
Yes, because he will insist on the prerogatives of the as chief executive of the United States. But Justice Marshall, who is said to be a genius on resolving that issue, decided that no person.
Yes, that decision was considered to be a touch of genius on his part.
Yes, because there are no.
Anyway, Justice, we are running out of time. Next question is, we go to the Constitution,
Yes.
1987. The 1987 Constitution definition of national territory clearly points to the Philippines as an archipelagic state. What do you mean by archipelagic state?
Archipelagic state is the opposite of the, in term of concept of what is an archipelagic state, is that the focus is on the waters, not on the land, not the terrestrial areas. So, exactly, Your Honor. Well, the exclusive economic zone,
Carpio, our EE, exclusive economic zone, is even bigger than the area of Metro Manila.
well,
So
exclusive economic zone.
Can you give us your definition of EEZ?
Exclusive economic zone refers to the 200 nautical miles from the outermost shore of the territory of a country, from the baseline or shorelines of the country,
From which the territorial sea
extends. And that by reason of that exclusive economic zone,
the territorial sea is measured.
yes, Your Honor. And on the basis of that 200 nautical miles, it grants under the UNCLOS that state to exploit all the natural resources, whether submerged or not. So including perhaps oil, aquatic and mineral resources that may be found under that exclusive economic zone, Your Honors.
I will ask you a question which has not yet been resolved, issue which has not yet been resolved by our Supreme Court. Supposing a supervisor of a company committed sexual harassment against a lady employee.
Yes, Your Honor.
He was found guilty, but he should pay for damages, but he had no money. Is the company subsidiarily liable? What do you think?
Where was the sexual harassment?
The
Inside the office.
inside the office of the supervisor. Convicted. He was convicted. No problem about it. The question is the company, because the supervisor has no money, subsidiarily liable for the damages sustained by the lady?
It's quite a difficult question, Your Honor, because subsidiary liability is specifically defined under the revised penal
We
code.
do not have any provision under the Constitution or under
Well,
any of our
If
laws.
that is the case, Your Honor, I will apply the law on equity.
By analogy, apply it. Yes, the company is liable.
Liable
So
to
that
the
is the
extent
end of
that
the
it is the
interview.
responsibility of each and every employer to assure the safety of the workplace.
Not equity, but by analogy, because under our civil code, even supposing a driver
Yes.
commits an act which calls for damages in favor of the passengers, he has no money. The owner of the vehicle is subsidiarily liable. So
That's
by
correct.
analogy, we can. So thank you, Justice.
Thank you very much, Your Honor. Thank you.
So call the last candidate, please.
Yes, Your Honor. The last candidate to be interviewed is Deputy Ombudsman for Luzon, OMB Gerard A. Mosquera. Deputy Ombudsman for Luzon, MB Jared A. Mosquera, Your Honors.
We will first administer your oath. May we request now Attorney Cayosa to start?
Thank you, Madam Chairman. Good morning, Deputy Ombudsman Mosquera.
Good morning,
Yeah,
Your
we have
Honor.
previously interviewed you extensively on June 8, 2011, when you applied for the position of Deputy Ombudsman, and also just last year,
Yes, Your Honor.
when you also applied for the position of Supreme Court Associate Justice. Now, may I just know, we opened since that time 3 other vacancies in the Supreme Court.
Yes, Your
But
Honor.
it is only now for the vacancy with the retirement of, expected retirement of Justice Mendoza that you have applied for the Supreme Court again. Could you tell us why have you applied only now since 2016?
Your Honor, I was completing a lot of work in the Office of the Ombudsman. I felt after discussing the matter with my family as well as soul searching that the timing was right this time after I've been able to complete some of the pending work that I am currently involved in the Office of the Ombudsman. So it's a personal decision, Your Honor. There was really no sense of timing, that there's no complicated process that I went through. It's just that I felt after consulting with my family that this is the right time to apply for a seat in the Supreme Court.
Since our last interview, has there been any significant development in your career, in your legal career, that would be worthy of note by the council?
Well, yes, Your Honor, foremost of which is that the last administrative case, probably the only administrative case I had last year, has now been dismissed by the Supreme Court. So I now am able to present an application without any administrative case. One of the principal programs that I am directly involved in the Office of the Ombudsman is the aggressive implementation of the Zero Backlog program of Ombudsman Carpio Morales. And this is something that I'm really happy to report on to the Honorable Council that as of this day, we are now working on the final 2015 cases in our docket at the Ombudsman Luzon. By the end of the month, we would only be handling 2017 as well as 2016 cases. So that would be something that I have been deeply involved in over the past few months, which have changed since the last time I was interviewed. Your Honor, please.
We have reports that there are still cases that were filed in 2015 that remain pending with the Office of the Deputy Ombudsman for Luzon. How do you monitor the actual cases that are filed to ensure that there is no delay in the referral to your office, particularly with resolutions of cases that have been pending before 2016?
Yes, ma'am. Ma'am, we have been very aggressive in conducting physical inventories. We have also been aggressive in monitoring the aging of the cases. In fact, ma'am, when, Your Honor, when the Honorable Ombudsman came in with her team, which included me, that was in 2011, there were cases as far back as 2001. Right now, our cases, in Ombudsman Luzon, we are now working on our final 2015 cases. By the end of the month, we would only be working with 2016 cases. Our target for the end of the year, Your Honor, is very aggressive. By the end of the year 2017, we target that all our 2016 and 2015 and earlier cases would have been resolved. So by the end of this year, we would only be working with cases that have a maximum age of 1 year, Your Honor. So we're hoping that we will be able to achieve this, especially under this is a centerpiece program of the Ombudsman, Your Honor.
We have reliable information that in the past, There were instances where in cases were deliberately withheld from resolution, and have action been taken against the individuals who deliberately withheld resolution
Yes.
in order that the principle on inordinate delay would apply and therefore would be ultimately dismissed
Yes, Your
or
Honor.
dismissible?
I'm happy to report to the Honorable Council that decisive action has definitely been taken against those responsible for officials that are responsible for withholding cases or retaining cases to the prejudice of the litigants. In fact, Your Honor, I have been designated early in my tenure as Deputy Ombudsman by the Ombudsman as the chairman of our Internal Affairs Board. This is the internal disciplinary body of the Office of the Ombudsman. I've been the chairman of this body since 2012. And in the course of my work as chairman, together with my fellow members, we have recommended severe sanctions against those officials, Your Honor. And there are pending cases in the Sandigan Bayan against them.
You spoke of delay, and I believe that the case filed against you by Fidela Vargas
Yes, Your
precisely involves delay. Could you tell us something about that case and how it was resolved in your favor?
Yes, Your Honor. The case of Fidela Vargas was, I think, dismissed late last year. But you're right, Your Honor, that it was discussed during my last interview. The complaint there was not really one of delay, but the fact that the complainant felt that I did not personally attend to his complaint. The way our procedure work in the Office of the Ombudsman, Your Honor, if I may be allowed to briefly explain, is that when complaints come in, and there are usually 10, 15 complaints a day, so hundreds in a month, the said complaints are forwarded to an evaluation unit, and this evaluation unit now decide where these complaints are to be referred, either for formal preliminary investigation or administrative adjudication, for fact-finding, referral to another agency, or to our Public Assistance Center, which is our frontline office. In the case of the complaint of Attorney Vargas, his complaint was immediately acted upon. It was referred to the evaluation unit. The evaluation unit referred it to our Public Assistance Unit, who acted and processed the matter. And there was, if I remember it correctly, proper notice to Attorney Vargas. The only reason was that I did not personally write the letter to her, and this was her main issue, Your Honor. When I explained this fully to the Honorable Supreme Court, and on that basis, the complaint was dismissed, Your Honor, please.
We also have here a position filed by Attorney Andre Zapanta.
Yes, Your Honor.
Could you tell us something about his complaint and how has this been resolved?
Yes, Your Honor. The letter of Attorney Zapanta was received by the Honorable Council at or around the time I was interviewed last year. If I may invite the attention of the Honorable Council, I was given the opportunity to submit a comprehensive response. But with the limited time I have now, Your Honor, may I briefly explain. When I was appointed to the office, this involved a case filed against barangay officials of a barangay in Antipolo City, Your Honor. There were a single set of respondents, but different complainants, Your Honor. So there were two sets of complaints that were filed by different sets of complainants. These cases were filed before I was appointed in 2012. Because of some administrative lapse, Your Honor, the two sets of cases were assigned to different bureaus. And what happened was that there were two conflicting resolutions. So when I came in, Your Honor, I met with my team, and we initiated measures to ensure that there was reconciliation of these two cases, and they were decided in the same way, Your Honor, considering that they involved the same facts and the same issues. So the complainant felt that there was a reversal of one of those decisions, but I explained in my comment that the reversal was necessary to ensure that there could only be one decision that comes out from the Office of the Ombudsman. So on that basis, Your Honor, I submitted my explanation to the Honorable Council. The said case, by the way, Your Honor, is now being prosecuted by the office in the regional trial courts of Antipolo. And we are fairly confident that we will be able to secure a conviction on that case, Your Honor, please.
Given your experience in prosecuting or resolving cases involving the application of RA 3019, the most commonly used provision requires manifest partiality or evident bad faith
Yes, Your Honor.
as an element of the crime. You would also, I think in the past you've also mentioned that sometimes this is rather an unrealistic standard, no? Especially since in the real world situations, it's very difficult to prove bad faith. So how would this affect how you would rule on cases involving graft and corruption? And what would you recommend, no, to improve the rate of conviction?
Yes, Your Honor. The law requires that the partiality must not only be simple partiality but manifest, that bad faith not be only bad faith but evident bad faith. So we really have to dig deep and gather evidence that would not just indicate bad faith per se, but bad faith that is so obvious and so apparent that once we file the case in court, the justices of the Sandigan Bayan will be able to see, just from reading the information, reviewing the evidence, that indeed there is in this case clear and apparent bad faith, clear and apparent partiality on the part of the respondent in the case. So again, this goes into the difficulty of investigating corruption cases, Your Honor, and it's something that I have also had the chance to share with the Honorable Council in the past. Yes, it's difficult. Yes, we may have eventually suggestions to Congress on how we can improve the Anti-Graft and Corrupt Practices Act, but until such time, we have to live with and work with the provisions of the law as it is. So we are really trying very hard, Your Honor, although we're having difficulties in establishing some of the elements pertaining to these types of offenses, Your Honor, when the requirements is quite general.
Now, there is a comment here that, and I quote, no, given your service record, his service record and experience in graft and corruption cases, it would be accurate to say that he would be more competent for the Sandigan Bayan at this point rather than the Supreme Court. Would you care to comment?
I would gladly serve in any branch of government, Your Honor. Early in my career, I have made a conscious decision to serve in government in whatever capacity. I would gladly serve in the Sandigan Bayan if the opportunity arises. But at this point in time, Your Honor, I do have this opportunity to put my name forward and my qualifications and my experience to be possibly considered for a seat in the Supreme Court, and I will not I will not be shy to say that to be in the Supreme Court, an associate justice of the Supreme Court, is the dream of any lawyer, Your Honor, please, and that's where I am right now.
So that was my last question, Deputy Ombudsman, and I wish you luck. Thank you.
Thank you, Your Honor.
Thank you, Madam
so
Chair.
much, Attorney Cayosa. Attorney Judge Julyl, please.
All right, thank you, Madam Chair. So it's still, it's no longer morning, Deputy Ombudsman. It's already 12:10. Afternoon na. Are
Good.
you not hungry?
Not yet, Your Honor.
Not yet.
Good afternoon, Your Honor.
All right, you have an impressive records here. You graduated from Ateneo, second placer in the bar, MPA. What's this MPA? Harvard.
It's a master's in public administration, Your Honor, please.
Also, LLM, King's College, University of London.
Yes, Your Honor.
Okay, you came also from the firm. 8 years in the government service. And you have also an impressive record, or rather, administrative cases. And you took pride of having the last case to be dismissed. What do you think attributed to these administrative cases in your legal career?
Well, one of these cases, Your Honor, reflects the nature of these cases. For example, the case there filed by Ronnie Faulbe. It's in my PDS, Your Honor, please. Ronnie Faulbe is a perennial litigant in the Office of the Ombudsman, but he is also a perennial filer of administrative complaints. He has probably filed administrative complaints against everybody in the office. So the moment he gets an unfavorable decision, he files a complaint against any officer who may have signed the resolution adverse to him. So my answer to that, Your Honor, is that I guess it goes with the work. We are not here as a judge or as an adjudicator to please any of the parties. That we have to rule on the merits, on the facts, as well as the applicable law. And sometimes some people will not be very happy with our decisions, and they will try to do these things to maybe harass us, to send a signal, a chilling signal, that the next time around we better follow the way there. But we take it in stride, Your Honor, please. We answer and we eventually get dismissals from the Supreme Court.
So there is also another position by a concerned public servant because of your physical encounter with the then Deputy Ombudsman for Luzon, Mark Calundone. That's way back.
Way back, Your
during
Honor.
your school days.
Yes, Your Honor.
About this opposition from Attorney Andre Zapanta.
Yes, Your Honor.
So, would you consider the Inareses as your friends?
I'm sorry, Your Honor.
The Inareses, Tito Inares,
Oh.
the family, how close are you to them?
I don't know them, Your Honor. I don't know any of them.
But there's a complaint filed against you by a certain Attorney Zapanta.
Yes, Your Honor.
Allegedly, you violated the rules to accommodate the political dynasty of the Inareses when the latter overturned the dismissal of one of the 7 cases against the former despite the long delay in the filing of the motion for reconsideration.
Yes, Your Honor. The allegation, Your Honor, is absolutely false. I do not know any politician in Rizal. In fact, I cannot remember the last time I talked to a politician while in the Office of the Ombudsman. I never talked to politicians. I never talked to anybody in the local government unit, Your Honor. The allegation is simply false. And the nature of the case, Your Honor, as I was given the opportunity earlier to explain to the Honorable Attorney Fernan Cayosa, that the allegation of Attorney Zapanta really arose out of an attempt of the office, arising from acts which took place before I was appointed, to reconcile the decisions. There were 2 cases filed by different sets of complainants against the same person involving the same facts, but were raffled to different bureaus in our office. And when we came in, it was our duty to ensure that these 2 decisions were reconciled, which meant that one would have to be reconsidered and the other one would have to be affirmed. That was the situation, Your Honor, please, in the pertaining to the complaint of Attorney Zapanta.
Okay, yeah. You were a recipient of scholarship grants
Yes, Your
from
Honor.
the programs of Mini Usmeña, Lopez, and Ayala.
Yes, Your Honor, please.
What did you do to qualify?
I applied, Your Honor. I submitted my credentials. I submitted my CV, my records, transcript of records, and the such scholarship grants, Your Honor, are grants under the management of Harvard, and Harvard is the one administering those scholarship awards. So my application was processed by the administration of Harvard, Your Honor, please.
Harvard,
Yes, Your Honor.
Mason's fellow program. What's this?
It's a program, Your Honor, please,
For
within,
construction worker, Mason?
spelled like that, Your Honor, yes.
Okay.
But it's a name of a person. It's Edward S. Mason, one of the promoters of international development, Your Honor, please. And Harvard named the program after him, Your Honor, please.
Or in the event that any of these persons or those who processed or granted your scholarship application appear before you or becomes involved in any case raffled to you, just in case you're going to be appointed as Associate Justice of the Supreme Court, what are you going to do? Semblance of interference or influence over you?
No, Your Honor. I will not recuse, Your Honor. The scholarship grants were granted competitively, Your Honor. I applied for it, and there were probably hundreds who also filed the same application. And I would like to believe, Your Honor, that I was selected as a recipient on the basis of that competitive selection. So I owe no person or organization a personal debt of gratitude for that. Of course, I am grateful in general to the grant, to the privilege, but not to any particular person that would constitute a basis for my inhibition or accusation, Your Honor, should any of those persons involved in the grant-giving bodies have a case before the Supreme Court, Your Honor, please.
And there's also a recommendation by a certain Father Albert Alejo and
Ye-
Bishop Cesar Vicente Punsalan.
Yes, Your Honor, please.
How do they know your professional competence?
Yes, Your Honor. I have worked in the area of anti-corruption with Father Alejo since the early 2003, Your Honor. So we have known each other for at least 14, 15 years. We have lectured together in the areas of anti-corruption, transparency, and accountability. On the other hand, Your Honor, please, Bishop Punzalan is, when he mentioned professional in his letter of endorsement or nomination for me, he was probably referring to the fact that we are fellow members of the volunteer members of the Philippine Bible Society, Your Honor, where we share a common ministry of distributing Bibles, Your Honor, please.
So, are you aware that there are clerics or high clerics critical to the present administration?
Yes, Your Honor, please.
And how about these personalities you have mentioned and religious orders will have a case before you if you're appointed to the Supreme Court? Will it not be the reflection of your bias or in favor of these clerics? or
I will
religious
not.
orders?
I will not be influenced, Your Honor, please, by any of them. I've always stood up for my principles and have resolved cases before me on the basis of the facts and the relevant evidence as well as the applicable law. Even if cases involving these clerics would come before me, as where I stand right now, Your Honor, I do not see any reason why I should recuse because I believe in my personal capacity to rule with independence, Your Honor, please.
So what is your reputation in the Ombudsman, in the office? What do your colleagues and staff call or describe you behind your back?
Your Honor, please, I have been chairman of the Internal Affairs Board of the Office of the Ombudsman for almost 5 years now. And that probably is one of the most difficult assignments I have in the office because it involves investigating your peers and most of the time investigating people that you work with and see on a daily basis, flag ceremony, meetings, and so on and so forth. But it's a job that was given to me early in my tenure. It's a job that was given to me, and I appreciate the trust accorded by the Honorable Ombudsman. And I believe I've done justice to that job, Your Honor. So my reputation, I believe, is somebody that is upright and has done his job in accordance with law, strictly in accordance with law, and applying fair play in everything and all dealings with the office, Your Honor, please.
All right, in a two-minute sales pitch,
Yes, Your Honor.
convince this council why you should be chosen for the coveted seat in the highest court over other applicants who are more senior than you are
Yes, Your
and have more experience than you do.
Yes, Your Honor, please. I've observed over the years, Your Honor, preparing for this opportunity, that there's really no single or best way to prepare for this highest position that any lawyer can aspire for. There have been a lot of jurists sitting in the court, and they have done a marvelous and a wonderful job in the Supreme Court. But I personally believe, Your Honor, that there is still room in the Supreme Court for somebody with my background, my educational background, my experience over the past 16 years promoting principles of transparency, accountability, and anti-corruption. And somebody with the track record that I have generated over working hard over the past few years. So I believe, Your Honor, please, that the Supreme Court will benefit from diversity, will benefit from members coming from diverse backgrounds, diverse experience, diverse work, Your Honor, please. That, in my humble way, is how I would present myself for this, in support of this application for a seat in the Supreme Court, Your Honor, please.
All right, last question, please. What difference in the world have you made as Deputy Ombudsman for Luzon?
I come to my work every day, Your Honor. I've been 5 years in the Office of the Ombudsman, but I'm still excited waking up in the morning and coming to the office at exactly 8 o'clock in the morning, because I believe that every day is an opportunity to impact on the lives of people, communities, and families out there. Every decision I make, Your Honor, every paper I sign in the Office of the Ombudsman, I always think that it will have a positive impact on the community out there. So I really, this position, Your Honor, and whatever position I am privileged to be in government, is always an opportunity to improve the lives of our fellow men, the people out there who rely on government, who rely on us to do our job with integrity, honesty, and independence, Your Honor, please.
So simply describe yourself in one word.
Honest.
Why did you
And
choose
upright.
honest? Why?
Because that reflects my character, Your Honor, which I bring and to any work that I do, and which hopefully I will bring to the Supreme Court. A related word would also be integrity, Your Honor, please.
All right, thank you very much.
Thank you very much, Your Honor, please.
Good luck.
Thank you so much, Judge Ilaw.
I'm really hungry.
Good afternoon, ma'am.
So I gather from your statement where you say you are well qualified, is that on terms of academic background, you are more qualified than any of the sitting justice in the highest court?
I did not say that, Your Honor, please.
That can be made, that can be a conclusion.
I was only responding to the question
just
to make a sales pitch, Your
Just say
Honor.
yes or no, so you don't intend to impress the
No, Your
counsel
Honor. No, Your Honor.
that academically you are more qualified than
No, Your
anyone
Honor.
of those justices.
No, Your Honor, please.
Okay, see. Were you already a deputy ombudsman when the case of Benjamin Cocoy Romualdez case or information was filed with the Sandigan Bayan? Do you remember the case of Cocoy Romualdez?
I do not remember, Your Honor, the
Okay,
case.
I will let you know the facts.
Yes, Your
and
Honor.
I will ask you whether or not the Sandigan Bayan committed an error. An information was filed against Benjamin Cocoy Romualdez for violation of Section 3E of Republic Act 3019.
Yes, Your Honor.
In that he was holding two positions as governor of Leyte and as ambassador to the United States. And because of that, the government was prejudiced and was injured. In terms of salaries, imagine he was receiving two salaries, so there was an injury on the part of the government. After the filing of the information, Cocoy Romualdez filed a motion to quash the information on the ground that the allegations therein do not allege the crime as defined under 3019 and because of prescription. You know the ruling of the Sandigan Bayan? The motion to quash was granted. Why? According to the Sandigan Bayan, the government did not suffer any prejudice or injury. So the ombudsman, do you remember now the case? You remember?
I did not participate in the case, Your Honor, but
you
I
know.
recall bits and pieces
Okay.
of it, Your Honor,
So
please.
the ombudsman went up to the Supreme Court on a petition for certiorari under Rule 65.
Yes, Your Honor, please.
Do you think the ruling of the Sandigan Bayan is correct? That the government did not sustain any prejudice or injury?
I disagree,
When
Your Honor.
Romualdez was holding two positions, and our laws and jurisprudence prohibit a government official to be employed or to hold two positions. What is your comment?
I disagree with the decision of the Sandigan Bayan, Your Honor.
Okay, you are correct. I also disagree. I also dissent. Now, what happened in the Supreme Court? In the Supreme Court, the first ruling was to remand the case to the Sandigan Bayan for trial. Okay, there was a motion for reconsideration filed by Cocoy Romualdez, denied. Second motion for reconsideration, alleging the ground of prescription, granted. So, what's your comment on the ruling of the Supreme Court? Will you have concurred or dissented? Second MR.
I will dissent, Your Honor.
On what ground?
I mean, it's a second MR, Your Honor, that should have been taken up during the first review of the case, Your Honor. And I am not so sure if the ground of prescription has any basis at all, Your Honor, please. I doubt that also, although I don't have the facts. But I will definitely dissent, Your Honor, please.
Number one, second motion is prohibited by
Correct,
our
Your Honor,
rules.
please.
Number two, prescription would not lie because
Yes, Your
on
Honor.
that ground requires a hearing.
Yes,
of the
Your Honor,
merit.
please.
Okay, so this will be the
And that
two
was
ones.
not, there was no factual hearing in the Sandigan Bayan, Your Honor, because
So both
it was a
Sandigan
motion to
Bayan
quash.
and the Supreme Court committed errors,
Yes, Your
right?
Honor, please.
Okay. So let's go to international law. What do you mean by EDCA? This case of EDCA.
The EDCA ruling, Your Honor, please, I cannot recall it right now, Your Honor, but yes, Your Honor. Defense Cooperation Agreement, Your Honor, please.
Okay.
Yes, Your Honor.
That case also reached the Supreme Court.
Yes, Your Honor,
And in
please.
fact, the decision was handed only last year.
Yes, Your Honor, please.
Okay. So under Section 25, Article 8 of the Constitution, it says, foreign military bases, troops, and facilities shall not be allowed in the Philippines except under a treaty
Yes, Your Honor.
as approved by the Senate, or if Congress requires by a majority vote of the people in a referendum.
Yes, Your Honor, please.
Referendum called for that purpose. Okay, what was the decision of the Chief Justice and by Chief Justice Sereno herself?
I think the issue revolved upon the characterization of EDCA, Your Honor, whether it was a treaty or an executive.
What was the decision? Did you read it?
I have read parts of
What
it, but
was
not
the-
in full, Your Honor,
What
please.
was
I'm sorry.
the Supreme Court on EDCA?
The ruling was that it was an, if I remember it correctly, Your Honor, an executive agreement, and as such, it was affirmed as something that could possibly be implemented, Your Honor, please. But I think the issue there is whether it's an executive agreement or a treaty. However, being a mere executive agreement, it would not be sufficient to justify the stationing of foreign troops within Philippine territory, Your Honor, please.
The ruling of CJ Sereno is that EDCA merely implements
Yes.
what? The
The Mutual Defense Treaty, Your Honor, please.
of 1951
Yes, Your
and
Honor,
what?
yes. Visiting Forces Agreement, Your Honor,
Agreement
please.
of 1988.
Yes, Your Honor.
So that was the ruling. But if you are a member of the Supreme Court, would you have concurred or dissented?
I would have dissented, Your Honor, please.
On what ground?
On the ground that the EDCA would authorize something that can only be done under a separate treaty, Your Honor, please.
But it is a mere implementing
Yes, sir.
bilateral agreement.
Yes, Your Honor, but
Isn't that
my
correct?
yes, my personal opinion, Your Honor, is that you would need,
Implementing also the Mutual Defense Act to the effect that America will come to our aid in case of war.
but the
And
mutual,
visiting forces agreement, you know, the American soldiers will merely
Yes,
train our
yes,
soldiers.
Your Honor, but the Mutual Defense Act, Your Honor, does not
Combat
authorize,
activities.
yes, Your Honor, does not authorize actual combat cooperation as well as stationing of foreign troops in the country, Your Honor. My personal opinion, Your Honor, is that an EDCA would not be sufficient, such that a treaty would have to be executed to justify stationing of foreign troops in the country, Your Honor, please.
There must be a treaty.
Yes, Your Honor, please.
Okay, so what's the difference between a treaty and a bilateral agreement?
A bilateral agreement, Your Honor, is an agreement only between the formal representatives of two countries. There is no need for Senate concurrence for it to be implemented, and that it is not necessarily part of the law of the land.
How is a treaty being terminated?
Your
How
Honor,
about bilateral agreement?
I'm sorry, Your Honor.
How is a treaty terminated?
A treaty is terminated by mutual consent of the parties and ratified by the appropriate legislative authorities, Your Honor, please.
An agreement of the signing
Authorities.
countries.
Yes, Your
Okay,
Honor.
how about bilateral agreement?
Bilateral agreement can be terminated unilaterally, Your Honor, please, by one of the countries, Your Honor, please.
No.
No.
Better
Yes,
research on that. The
Yes,
answer
Your Honor.
is not correct.
Yes, Your Honor.
Anyway, let's go to the right to die.
Yes, Your Honor.
Do you think there should be a law in our country authorizing people concerned the right to die? That a violation of the constitutional provision that no person shall be deprived of life, liberty, or property without due process of law?
I personally believe, Your Honor,
Right to
that,
die or the right to suicide
yes, euthanasia, Your Honor. please.
attended.
Yes, Your Honor. I personally believe, Your
Or
Honor, that-
suicide, the right to attended suicide.
assisted suicide, Your Honor. I personally believe, Your Honor, that the Philippines should not have a law providing for legalized or assisted suicide, Your Honor, please. But not on the right to life, the prohibition or the protection against the deprivation of life, liberty without due process of law. But on principles of the Constitution protecting life, Your Honor, in general, Your Honor, please.
You studied in America.
Yes, Your Honor.
Do you know the decision of the U.S. Supreme Court on the issue of the right to die or on the issue of assisted suicide
I am not.
penned by Chief Justice Rehnquist
I have not had the opportunity.
away 2 years ago?
Yes, Your Honor. I have not had the opportunity to review those decisions, Your Honor, with the U.S. Supreme Court, Your Honor.
Because the state of Washington passed a law authorizing assisted suicide. And then the issue reached the Supreme Court.
Yes, Your Honor.
And the ponente was Chief Justice Rehnquist. So he conducted a research on what was the mind of the framers of the Constitution. Did they intend to have incorporated this issue, even silently, in the United States Constitution? And then he traced that since 1400, England and its colonies prohibited assisted suicide or the right to die. And therefore, he concluded that because of this finding, the framers of the Federal Constitution did not intend that this right to die should be allowed. So anyway, that there is the signal.
I totally agree with that ruling, Your Honor, please. I believe that
So
the
even
Constitution...
under our Constitution, even under our pursuant our tradition,
There is simply
that
nothing in
has
our...
never been allowed.
Yes,
Okay?
there's simply nothing in our Constitution, Your Honor. I believe in the strict interpretation and application of the Constitution and the relevant law. There is simply nothing in our Constitution and our legal tradition that would even
But
hint.
are you aware of of what they call living will being left by the parents to the children, instructing the children that in case they are hospitalized, they will not allow any tube or tubes to be inserted in their bodies, and that they should be allowed to die. Are you aware of the living will being done now by most families?
I have heard of that, Your Honor, please. DNRs, do not resuscitate instructions, Your Honor, please. I certainly do not agree.
Is that in accordance with our Constitution?
It is not, Your Honor, please.
That can be, raised as an issue before the courts.
Yes, Your Honor, please.
You?
Thank you, Your
Lang?
Honor. Thank you, Your Honor.
Public interview is now adjourned. Thank you so much. Thank you, my dear audience.